George, a rug importer, gets a call from his transport company. They've miscalculated their mileage. If George doesn't pay double the agreed rate, they're pulling the truck over and leaving his entire shipment on the side of the highway. Meanwhile, Kate, a hospital consultant, sits at her kitchen table and signs a second mortgage on her home. She doesn't read the paperwork. She's doing it because her partner told her his business needs the loan, and she always leaves the finances to him. Contract law rests on a strict foundation. Agreements are only binding because both parties freely consent to the terms. But when that consent is extracted through illegitimate pressure, the law steps in. The contract becomes what we call vitiated. A vitiated contract isn't automatically torn up. It is not void ab initio, or void from the beginning. Instead, it becomes voidable, meaning the innocent party has the option to cancel it.
The common law provides two distinct pathways to prove consent was vitiated: economic duress and undue influence. There is no remedy of damages for either of these actions. Your only option is the equitable remedy of rescission. To get it, you have to accurately identify the exact boundary where hard commercial bargaining crosses over into unlawful coercion. Historically, proving coercion was straightforward. Duress was strictly confined to actual violence or illegitimate threats to a person's life or property. In the case of Barton v. Armstrong, a company executive was threatened with death if he didn't buy out his colleague's shares. But the evidence showed he actually thought the buyout was a satisfactory business deal anyway. The legal issue was whether the death threat had to be the sole motivating factor for entering the contract. Lord Cross ruled that the threat only needed to be a reason for entering the agreement. Once the claimant shows a threat was made, the burden of proof shifts to the defendant to prove the threat contributed absolutely nothing to the victim's decision. Physical violence is rare in modern corporate disputes. Instead, we see economic hostage-taking. In Atlas Express v. Kafko, a haulage company demanded more money per delivery and threatened to simply breach the contract and stop all shipments if the client refused. The client, Kafko, was a small manufacturer completely reliant on their contract to supply Woolworths. If the delivery stopped, they would lose their biggest customer, and they couldn't find another carrier in time. The court ruled this was an illegitimate threat to breach. Kafko's agreement to pay the higher price was voidable because of economic duress. Today, we evaluate economic duress using the strict three-part test established by Justice Dyson in Coercion Construction Ltd v. Felix Ltd. First, the pressure's practical effect leaves the victim with a complete lack of choice. Second, the pressure itself must be illegitimate, like an unlawful threat to breach a contract. Third, that pressure must be a significant cause inducing the agreement. Be careful not to confuse this with the rules of consideration. Under Williams v. Rafi, performing an existing contractual duty can sometimes be valid consideration for a promise of extra money, but that exception immediately vanishes if the promise is obtained through duress. Economic duress requires a precise combination of an unlawful threat and a trapped victim. Mere inequality of bargaining power or an aggressive negotiation tactic will not meet the threshold. Because a contract procured by duress is merely voidable, the victim must apply to the court to rescind it, and that right can expire. The courts apply specific equitable bars to rescission. You lose your remedy if third parties have acquired rights, if restitution is impossible, or if you wait too long or affirm the contract. The Atlantic Baron illustrates how victims lose cases through delay. Shipbuilders demanded extra money mid-construction, threatening to stop work. The claimants paid out of necessity. The ship was delivered, duress evaporated, but they waited 8 months to ask for repayment. The court viewed that 8-month silence as an affirmation of the variation. Failing to act immediately once the economic gun is removed from your head acts as a legal endorsement of the contract. The second pathway to vitiated consent is undue influence. This doctrine targets relational abuse that goes beyond acceptable persuasion, specifically addressing manipulation that happens behind closed doors. There are two evidentiary routes: actual undue influence, where the claimant must prove the coercion directly, and presumed undue influence. The House of Lords laid out the definitive test for presumed undue influence in Royal Bank of Scotland v. Ettridge. The first mandatory prong requires establishing a relationship of trust and confidence between the parties. The law automatically presumes this trust exists in certain dynamics, like doctor and patient. For others, it must be proven on the facts. In Tate v. Williamson, A financial advisor exploited an extravagant Oxford undergraduate by buying his estate for half its true value. You can also prove a relationship of trust in commercial settings, as seen in O'Sullivan v. Management Agency Limited, where a young, unknown singer placed complete trust in his manager to handle his affairs. Returning to the Ettridge test, establishing trust is not enough. The second prong requires that the transaction itself must call for an explanation. It cannot be readily explicable by the normal relationship between the parties. The tripartite problem involves a creditor, a debtor husband, and a surety wife. The bank didn't exert undue influence, but relies on the wife's agreement. Under Barclays Bank v. O'Brien, banks put on inquiry must investigate. Ettridge confirmed non-commercial guarantees automatically trigger this inquiry. Once on inquiry, the bank must take reasonable steps to protect itself. This means ensuring the surety attends a private meeting with a bank representative or receives independent legal advice about the risks. In practice, banks satisfy this by requiring written confirmation from a solicitor, guaranteeing the surety fully understands the inherent risks of the security agreement. Watch out for this in exams. If the loan is advanced jointly to both parties, as in CIBC Mortgages v. Pitt, the bank is not put on inquiry. Because the loan appears to be for their mutual benefit, the bank has no reason to suspect coercion. The Ettridge Doctrine forces commercial institutions to act as the final checkpoint for free consent. If a bank fails to investigate a non-commercial guarantee, the law transfers the risk of domestic financial abuse squarely onto their balance sheet. Let's apply these rules back to our opening scenarios. George's hauler demanded an extra £200 to finish the deliveries. Applying the Coercion test, Mercator's threat to breach the contract was an illegitimate pressure. Because George faced the immediate loss of his main client, Threadworth's, he had zero practical choice. George can successfully claim economic duress and rescind the price variation, but he must notify the carrier and act quickly to ensure he doesn't hit the equitable bar of delay. Next is Kate, who signed away her home equity for her partner's business without even reading the legal documents. Applying the Ettridge Doctrine, the relationship was non-commercial and the loan was not for their joint benefit. Kate had no stake in the business, which means Quality Finance was immediately put on inquiry. The bank failed its legal duty by simply dropping the papers off at her house and failing to demand written confirmation from an independent solicitor. They did not take reasonable steps to protect her consent. Kate can rescind the security agreement based on presumed undue influence. The bank loses its collateral entirely and is left chasing her partner as an unsecured creditor. Contract law aggressively protects commercial certainty, keeping businesses bound to their deals. But the courts of equity act as a vital fail-safe, intervening to unravel transactions infected by coercion. When you encounter illegitimate pressure in an exam fact pattern, never attempt to claim damages. Always assert that the contract is voidable and immediately analyze whether the victim acted fast enough to avoid the equitable bars to rescission.